Good morning, ladies and gentlemen. Welcome to our third edition of the Data Privacy Day. So I'm very happy to see that such a large number of you has found a way today to Belval for having a great conference about data privacy. And we also try to raise some awareness in data privacy. So please watch where you leave your data and please check what people are doing with your data. So I am Cynthia Wagner, I'm from the Restina Foundation, and today, together with my colleague Christian Hütter, the CISO from the University of Luxembourg, we will guide you through this conference today. So now it's an honor for me to welcome our first keynote speaker, which is Christophe Buschmann from the CNPD. Please, Christophe, the floor is yours. Thank you.
Hello, everyone. I'm really happy to welcome you to this Data Privacy Day, which, as you might know, is organized in the framework of the European Data Protection Day, which is held every year on the 28th of January since 2007. Now, I don't know how many amongst you know what the origin of this date is about. Actually, 28th of January was the date where Convention 108 has been signed, which was the very first internationally binding framework for processing of personal data. So nowadays everybody is talking about GDPR, but what I would like to stress out here is that data privacy, data protection goes back way beyond GDPR, actually 39 years. And Convention 108 is not limited to Europe. Actually, for the moment, there is 55 countries who adhere to Convention 108, which has been updated this year. So I think this sets the context, which means that data protection, it's a core European value, which is shining all over the world. And I think we can be very proud as Europeans that we have a leading role when it comes to data protection. So the goal of the Data Protection Day in Europe is to raise awareness. Now, talking about awareness about data protection, personally, I was a bit scared after 25th of May that after this big buzz of GDPR, the topic would, to some extent, be lost, be replaced by some more concrete, more tangible issues that people prefer talking about. But I think it's safe to say that at least in 2019, data protection was pretty much still on the agenda. I mean, not that I was necessarily happy for all the things that have been noted during 2019, but it's clear that people do care about data protection. Now, why those topics that have been discussed in 2019 were discussed with so much passion, I would say. I mean, let's go back. It started with background checks during a recruitment process, or background checks for invitations to a public event. Now, one could see this as a rather abstract process, but I think what became clear during the discussion was that such background checks, they can have a real impact in your real life. I mean, where you work, the workplace that you get or that you don't get, will affect in a very serious way your life. So it made data protection very tangible. It demonstrated the link between what happened in a theoretical way during a recruitment process with personal data and what the outcome can be for you afterwards. After that, the discussion continued and got a bit broader. It was the more general practice of processing personal data with police and justice. And what struck me was that for the first time in such a scale, I would say, the discussion approached the fact that data protection is not just one simple thing. It's a complex matter with finding balance between different priorities that you can have between safety on the one side, privacy on the other side. So the discussion at least reflected to some extent this difficult equation that we need to solve. It also demonstrated for the first time that in order to safeguard our security, some data needs to be processed. Some very sensitive data needs to be processed. And at least I think it's safe to say that many citizens were surprised on the extent and the depth of data which is actually used by police on an everyday basis. Then, a bit later in 2019, it was a very interesting moment for myself, because the discussion on video surveillance, which started early in 2019, got wrapped up again. But now, the perspective was not the same anymore. At the beginning of 2019, the discussion about video surveillance was pretty much, we have a problem with security, we need to put cameras, this will solve the problem, and if there is legal problems with that, well, then we need to change the text, because that's what we would like to have. I was happy to see that towards the end of 2019, at least there was a discussion about the fact that there might be a difference between the perceived security and real security, and that the difference between those goes at the cost of privacy to some extent. So all this being said, I was not unhappy to see that discussions were in the public about data privacy, and that we touched upon some of the more complicated things that come with this topic. But privacy was not only a discussion on national level in 2019, it was also a discussion on more international frame. I remember at the beginning of 2019, there were long discussions about smart speakers, about transcripts, the usage of artificial intelligence, to what extent it's acceptable that there is human beings listening to those utterances that were generated through the interaction with smart devices. And there again, I think we are moving into the right direction. We made the step from just wanting to have the benefits of artificial intelligence towards identifying at least there might be some risks that we would like to get covered with those technologies. So to wrap up, I think we can say that there is still real interest in data privacy. Citizens are very clear that they care about privacy, and the topic is in the focus. So that's nice so far. I think that's far from being everything that we need to have, because being in the focus is one thing, and then managing to transform this priority that citizens do express into something tangible, something real, that's a whole different story. And you hear the first voices coming up that there is some kind of frustration. Some organizations, some associations, they feel that their complaints are not handled in the correct way, that the reply that is given by supervisory authorities like CNPD or by some others are not sufficient to really make this topic move. And I can understand those frustrations. And I think, while I must admit, I think GDPR is or was a game changer, less because the rules changed, but more because the approach changed. But we are far from having done our work. I think GDPR was just the beginning, and we need now to find a way how to make those principles work in practice. So it's still a long way to go, and I don't want to give the impression that the battle is already won. I think we got some push from the citizens to know that they care, but now we must make sure that we don't miss this opportunity as it was missed before. I mean, before GDPR, nobody can say that data privacy worked. It was a paper. It was some rules that were written on a paper, but most of the organizations didn't care. And there is still a risk that this can happen again. So we must stay focused to make GDPR work. And I see GDPR, to some extent, as a second chance to not reproduce the mistakes that were done in the past. This being said, obviously, we live in a world where change is happening fast. I'm not the first one to say this, but I'm pretty sure that in a couple of 20, 30 years, if we look backwards, we do all agree that change did really happen extremely fast. And the change is not only happening fast, but it's also very profound. You have social networks that today they have the power to interfere with democracy. I mean, that's something that has never been seen before. Organizations that exist for a decade, they have now the power to really interfere on democracy or elections. You have e-commerce, which has grown up to a volume so that it really impacts the way we spend the money. But the way we spend our money, it's one of the most important ways to express where we would like to see priorities. It's the way where the shops we go, the things we buy. Now we have e-commerce companies that completely change the way how we spend money. We have new technologies that completely change the way what is possible in terms of surveillance. And I would say most of all, in the meantime, we have organizations that have yearly turnovers which are higher than the ones of nation states. So this is new. So you have organizations today that have more power than states. But we should not forget that an organization is not the same that a democratic nation state. So this is a situation where we need to be aware when we do our changes, our choices. And I think one of the biggest risks for the future that will come is that I see a huge risk of disengagement from the citizens in regards to the technology or the services that they use. Those services are presented in a very complex way. Artificial intelligence, nobody knows what it is. It's a black box, but it's a huge company behind. Just trust us, we are doing all we need. And all this, to some extent, it's a way to express power. So there is huge power shifts happening right now. And be aware that someone who doesn't want to be transparent, he might want to use this intransparency for his own advantage. And I think letting this happen would be a big mistake for the future. So we should not disengage. We should not be afraid when we see complex technologies, complex changes happening. I think we have an obligation to be interested in what happens and to influence on what happens. And I think GDPR, as well as other frameworks, they give us rights and powers. So just to highlight this, I found two figures which I'm not a statistician, but they might still give you some hints of what I mean. If you take the Eurobarometer on data protection from, I think, earlier last year, there's more than half of the people who say that they are not comfortable with the fact that organizations do profiling or they do collect personal data as a counterpart to offer them services for free. They are not happy, they are not comfortable with that. But now, I don't have the figure at hand, but I'm pretty sure more than half of the people, they rely on those services. So we do rely on things, we do things where we are not comfortable with the way they happen. So to some extent, there's a contradiction in this. So if we want to influence the way things happen, we should also exercise choice and choose those organizations that do process our data in a way where we are comfortable, and not the opposite way. Another data protection Eurobarometer states that 67% of Europeans are aware of GDPR. Okay, it's nice, but that means that 30% are not. And those 30% who are not aware of GDPR, I'm pretty sure that they are not aware of their rights. I'm pretty sure that they are not aware of the fact that they have the right to ask what data is processed and how it's processed, and that they have the right to stop processing of some data. And I think that's one of the huge opportunities where we can have an influence on the way data is processed by private organizations and by the public in the future. So on this, I wish you all a very interesting day, and I hand over to the next speaker. Thank you very much.
From the University of Luxembourg, Laurent Prévotat, Data Protection Officer at Luxembourg Institute of Health, and Chloë Lellinger from the Data Protection Officer at the Luxembourg Institute of Socio-Economic Research. The three of them will present you today their experience and problems they observed during the last few months in GDPR.
Thank you, Cynthia. So it's really a pleasure for me to celebrate with you today the Data Privacy Day. in research, in public research, we have various challenges to implement the GDPR, and we want to implement properly, because Christophe also explained what are the challenges, and now the phases is implementation and proper implementation. To do this presentation about these various challenges for public research, I ask the participation of Laurent and Chloé to join me to explain you these different challenges, and we will not examine all these challenges, but we will focus on some of this. And we hope that at the end of this presentation, you will also have an overview, a better overview of the challenges and the importance for the research. Now I will leave the floor to Chloé to do the introduction of her presentation. Thank you, Chloé.
Thank you, Sandrine. So to maybe introduce the topic on challenges on data protection in research, I will introduce the two fundamental rights that are data protection and the right of privacy. The European legal framework is actually based on a human-centric approach. And this human-centric approach means that our legal framework tends to protect human beings amongst states and private interests. And it means also that we in Europe want to protect personal life, personal data, privacy, and also the freedom of speech and sciences. So this is actually quite a conflict. We can see it as a conflict because the scientists and the researchers can explain you how free they want to be to perform research and to have the better knowledge and to create the better knowledge and better innovation for European citizens, but also for international framework. But actually, this is not so quite a conflict, and the legislator has think about it and find a way to come with a solution for an imbalance between those two rights. So this as a first introduction. Now I will introduce you to the scientific world and what is a scientific research. And actually, the former EDPS supervisor Giovanni Buttarelli said that the biggest challenge maybe from the 21st century is to define what is genuine scientific research. So I will leave you with these thoughts and will not bring you with a theoretical definition of a research, but I will try to picture you what we are doing in our institution. So we are a public institution willing to perform systematic activity which increase the stock of understanding and knowledge and the application. So we as a public institution are acting in the context of public funding. So we are getting public funding from the Ministry of Education, of Higher Education, and also from the FNA and maybe potentially from the European Commission. And we also based our research on ethical standards, and so yes. In order maybe to find a solution between this conflict of rights, the legislator so thinks about a solution to imbalance those two rights, the personal data, yes, privacy, of course, but how to conduct free research in those contexts. So in the GDPR, you can find a set of specific derogation exception for the scientific research, and it's appeals to the legitimacy to process sensitive categories of data, presumption of purpose compatibility, derogation to subject rights, derogation to some transfer to a non-European country, and derogation to data retention limits. So these are the specific derogation for scientific research. but of course it does apply with some safeguards. We will talk about them.
Good morning, everyone. I'm the one to introduce the next slide very briefly. So here are the main challenges that we face to as public research institution. And following some discussion with my colleagues, we decided finally to focus on few specific ones. So as you can see, we'll talk today about the legal qualification of the parties, the performance of the data protection impact assessments, the transfer of personal data to third countries, and finally, we will talk about the further processing for research purpose. So I propose now to start with the first topic and give the floor to Sandrine.
Thank you, Laurent. I know that the legal qualification of the party is not only the challenge of public research, but we also face in the area of research. That means that we have specific legal qualification in the GDPR. We have controller, joint controller, and processor, and we have to face also this issue of legal qualification of the parties. So for us, it's the first key point and the first challenges of implementation of the GDPR, because it determines the obligations and also the contractual frameworks. Why? Because in the GDPR you have specific obligation depending on your role of controller or the role of controller or processor or joint controllers. And also in the GDPR there is specific articles about the obligation if you are, and about the agreement that you need if you are if there is a contract between a controller and a processor, or if there is a necessity to have a contract between joint controllers. So my advice and our advice, because Laurent and Chloé join me in this assertion, is not to underestimate the data protection aspect in agreements, because what we see in the daily work is that in terms of agreement, time is needed, and also clarification about the personal data processing is needed. So in research, I would say that the legal qualification is quite complex and source of interpretation. So we are doing on a case-by-case basis and in relation with the personal data processing carried out by the different parties. So we could say that in research world there is a lot of agreement with, and there is a lot of collaboration, and that often leads to the legal qualification of joint controllership. But sometimes, depending on the personal data processing carried out, we also have the situation of a research institution qualified as processor. For example, when this research institution provides services. So I will give you an example. So I imagine a scenario to explain you the point. So we have the context, that is a public institution A that wants to lead a research project with a public research institution B, and they want to ask the services of a public research institution C to collect health data without participation of C to the research project. And A and B will decide who will have access to the personal data and which means will be used for this collection, processing, and so on. For example, we can use the means of specific data secure fly or platform. And so we can say that in this situation, A and B may be qualified as joint controller and C as processor. So what will be the consequences in terms of agreements? So as I explained before, you have two specific articles about the agreement in the GDPR. So now we have A and B that are joint controller, so they must conclude a data sharing agreement or data collaboration agreement. And you have also the situation of A, B has joint controller and C has processor. So it's also mandatory to have an agreement between A, B, and C. That is a data processing agreement in accordance with Article 28. So as we also face this scenario with joint controllers, it's necessary that the joint controller clearly clarify the responsibility in the agreements. The GDPR mentioned that they have to handle the information and exercise of data subject rights, but I think that it's necessary to go further to also discuss the point about the record of personal data processing in the case of personal data breach, and if needed, also how it will be handled if a data protection impact assessment is needed. What I will also recommend is in the agreement to define dedicated contact point for data protection aspects. Most of the time, that is the contact details of the DPO of the institution. And also, we see more and more, and that is good, annex in the agreement also to specify what are the personal data processing done by the party and what are the task allocation of the parties. So that is the point about the first key point, that is the legal qualification of the parties, determine who is controller, processor, joint controller. Afterwards, depending on the risk of the personal data processing, it's also necessary to check if a data protection impact assessment is needed. So I will leave the floor to Laurent that will explain you more about the DPIA.
Okay, so for the data protection impact assessments. First of all, I think it's very important to give you, or maybe to remind you, the definition of the data protection impact assessment. So a DPIA is basically a risk assessment focused on privacy and aims to identify and analyze how privacy might be affected when personal data are processed. And one of the questions is when such a DPIA has to be performed. The CNPD delivered in March 2019 a blacklist, which is basically the list of all the processing operations where the performance of a DPIA has to be done. And as you can see, the processing, if you process personal data for scientific or historical research purpose, then a DPIA must be conducted. But what's a privacy risk? Privacy risk, that's a risk that impacts the rights and freedoms of individuals. And I will give you there just very high-level examples of this kind of risk. First, if someone processes your personal data without your knowledge, okay, and for another purpose, for what they have been collected initially, that might impact your privacy. Another example, if sensitive, personal and sensitive information about your health are disclosed to your employer without your authorization, maybe this can lead to lose your job. Third, once again, if very sensitive information about your life habit, let's say like your sexual orientation, is disclosed to someone by hacking, maybe the hacker could use it in order to harass you. And then, last high-level example, if you plan to use a new technology that is maybe too intrusive into your private life, then that's also a privacy risk. So the DPIA consists finally in assessing three main categories of risk. The one that can lead to an illegitimate access of your personal data, or the one that can lead to unwanted modification of this data, or finally, the risk that can lead to the disappearance of your personal data. And all in all, the DPIA helps to set up or consolidate technical and organizational measures within your organization in order to control or at least to better protect the personal data. So consequently, the privacy of the individuals. But how to run this DPIA? And this is clearly one of the challenges we have as a public research institution, but maybe not only the research institution. So first, we have to define a methodology. And ENISA and the CNIL provide good methods for privacy risk assessment. At LIH, we decided to follow the CNIL one. But you know, even if the CNIL provide examples and templates, you always have to adapt it to your own organization and also to the way you want to run this kind of exercise. Then you also have to design a proper process in order to manage the risk assessment. And you have to ensure that this new DPIA process connects well with other internal processes into your organization. Because I remind you that a DPIA must be done before to start any new personal data processing activity. So we have the method, we have the tools, we have the process, and then comes the question, who will be part of this game? At LIH, we have GDPR point of contact in each of our research departments. And there are clearly valuable links between the department and I. Of course, we also have the chance to have a risk manager who will take care of all the risk assessment part and the different interviews with the involved parties. And of course, we have the owner of the processing activity. So the PI, the group leader, the project manager, basically that's the guy who knows everything about how the personal data will be processed in this project or in this context. And at the end comes the DPO, who will review the final DPIA and provide recommendations when necessary, of course, in order to increase the level of protection of the personal data. Then finally, I would like to give you maybe a short and brief overview of the privacy risk assessment principle. So the use case here is a case where we want to assess the risk of unwanted modification of data into a study database. And in this database, we have specific generated data that will be used ultimately by the physician in order to adapt the treatment of a patient suffering from a gastrointestinal cancer, okay? So we are clearly in a case of personalized medicine. So now we will run an assessment of this risk. And clearly, if we make a first assessment without any mitigation, the first question is if this risk is applicable or not. Yes, clearly we are in a case of this risk is clearly applicable. And what's the impact? Of course, the impact is huge. Because indeed, if we made an error when entering the data into this study database, it means that consequently, the physician will deliver the wrong treatment to the patient. And as you can imagine, how catastrophic could be this kind of situation. And of course, once again, without any mitigation measures, the likelihood is really high, so it's very possible. So the gross risk value is also high, and it means that we really have something to do. Fortunately, we implemented mitigation measures, you know, like specific training for experienced staff. We also implement access rights management in order to give the access only to the people who are properly trained. We also implemented such, I don't know if you know, but input masks who are there in order to avoid to enter errors in the data. And we also implement monitoring. And monitoring is there in order to control that the data that have been entered are correct. Then in this privacy risk assessment method, we have to analyze the second time the risk. Now taking into consideration the mitigation measures. And as you can see, the impact is still maximum. Yes, because all the measures that we have implemented finally play only on the likelihood, but don't play on the impact. But we can see at least that likelihood now significantly decreased, the gross net value decreased also, and the risks became acceptable. But if it's not the case, if all the mitigation measures you have implemented are not sufficient enough to reduce the risk, then it means that the residual risk is too high, and we have to notify the CNPD, who will then perform a new assessment and at the end decide if maybe we can still start the processing activity under certain circumstances, or if we don't have to start this processing activity. Just a few words. Now, just to bear in mind that each time that you process personal data, you may put them at risk. And the DPIA, finally, aims to identify measures to reduce as lower as possible this kind of risk. Thank you for your attention. And now I give the floor to Sandrine for the next topic.
Thank you, Laurent. So now I think that as we are we are worldwide, so the research has no border. I wanted to discuss about this topic of transfer of personal data to third countries. That means that outside European Union and European Economic Area. So for sure, the principle is that the sharing of personal data has to be ruled by a contractual framework. In the research world, there is the research institution aim to perform projects with partners all around the world. So that involves transfer of personal data to research institutions that are located outside European Economic Area and European Union. So there is specific provision of the GDPR about what we call the transfer of personal data to third countries. The GDPR requires what we call implementation of appropriate safeguards, excepted if there is what we call an adequacy decision. That means that the European Union considers that the country of the research institution outside the European Union is considered as offering the same level of protection that European data protection regulation. And you can find the list of this country on the website of the CNPD. And I would like to stress that it's also necessary to check if this adequacy decision apply to academic world and research institution, because that is the case of two countries that this adequacy decision will not apply to research and academic. So just 1 minute about a focus on UK, because I know that some of my colleagues and some research institution has collaboration with research institution in UK. So now the withdrawal agreement is signed, so the UK will not consider as the third country. That means that the UK during 2020 will apply the GDPR. And after, we hope that will let the time to conclude an adequacy decision with UK. So I think if you have current collaboration with UK, at the moment they apply the GDPR. The question is after 2020. So in case of absence of an adequacy decision, or in case if not the UK, an appropriate safeguards must be implemented. What that means? Most of the time in research we conclude what we call the European Commission Standard Contractual Clause. So to give you an example, you have a research institution A that is located in Europe and that wants to collaborate with a research institution located in Australia. So there will be collection of personal data in Europe and in Australia and sharing of personal data in both sides. So my advice would be to conclude these standard contractual clauses. And in this standard contractual clause, you can see that the European institution is the exporter of personal data and the Australian institution B is the importer of personal data. So the standard contractual clause are used as what we call appropriate safeguards. But we have some comments about this standard contractual clause because they are not fully, they were adopted under the regime of the directive, they are not fully adapted for the research, and they are also source of discussion and education with the partners outside the European Union. So a revision of this standard contractual clause is expected in 2020, and there is also the alternative of asking the explicit consent of the person or the research participant that you will transfer personal data, but that is under the regime of derogation. So that is my point about this research without no border and the specific requirement of the GDPR. So now we discuss the different key points, the different challenges in terms of implementation for a first collection in research. But the research also use the personal data for further processing. So I will leave the floor to Chloé to explain you these last challenges.
So I will talk about further processing for scientific research purposes. So as you may know, the purpose limitation is one of the pillar principles of the data protection. The origin is actually to be found in the Convention 108, which requires that the information to be appropriate and relevant with regard to the purpose for which it has been stored, and actually prohibits its use for purposes other than those for which it has been stored. It means that a particular attention shall be given to ensure that the data will not be used to support measures or decisions that was not specified to the data subject at the collection time. In a more concrete way, it prohibits that bank, for instance, collects data for managing of a bank account, does not transfer those data to an insurance company, for instance, to allow or not the insurance of a customer. As it has already been mentioned, this purpose has a derogation for scientific research purposes. It means that we can assess a compatibility test to make sure that the data can be reused for scientific purposes. It has actually a big importance in the research area right now, because the most of the data are actually collected by private companies. And as public institution, we aim to access to those data in a public good. It means that we maybe would like to access to telecommunication data in order to assess the mobility within Luxembourg and the greater region. But how to do it? Because at the first time the data was collected in order to, from the telecommunication company, in order to invoice the customer their services. So, the GDPR actually provides this derogation, and it has to be assessed in order not to, and in order first to put some safeguards around this reuse of data and change of purposes. We as research institution have to make sure that those data are used and processed in, actually we speak about ethical way, but in a way that will not impact the data subjects. And we talk about ethical because the research community is actually has a very important ethical framework, and this has a very strong importance in the scientific research. But actually in Luxembourg right now we are a lot discussing about what kind of safeguard should we provide the data subject about the reuse of their data in our activities. So we have some measures that are actually provided by the Luxembourgish law. So we have some instant data management plan to be written and to be followed, encryption measures, use of privacy enhanced technologies, use a user authentication and traceability, anonymization if it's possible, and then you go outside of the scope of the GDPR, and then pseudonymization. Actually, pseudonymization actually only provided to those purposes can be filled in those manners. It means that in some of the research you can be performed by researchers. It actually has to be to have the raw personal data, so to have a direct contact with the participants, and the data cannot be fully pseudonymized, so if it's possible. We are also discussing some safeguards, meaning is a public funding, the assessment to receive a public funding be received as a safeguard, yes or no? It's in the discussion. The ethical approval, as already mentioned, and other to be discussed. Actually, it's maybe the best point to say that we have a working group around the research community between DPO. So we are talking a lot about the specific derogation applying to research and finding the best way to apply them to research purposes.
Thank you very much, Chloe. So I think that I hope that we gave you an overview of the main challenges in research, and I really thank you, Chloé and Laurent, to join myself to do this presentation, because I think the collaboration with DPO of institution is very valuable, and that also help us to improve this implementation. So now, if you have any question, do not hesitate.
So our next speaker will be Christophe Buschmann from the CNPD again. Christophe, the floor is yours, and you will speak about on-site visits and something else. Sorry for that.
So hello again. Now you have to deal with me once again. What I would like to share with you is some insights on the one side how we do our investigations, and I would like to illustrate this on a practical example, which is the DPO investigations, which are ongoing since a while, and I think it's worth giving you some very practical advice on what we came across, because it might help you in your process. So investigation. So with the paradigm shift of GDPR, so this change of approach, you might all be aware of the fact that we don't have this prior authorization anymore, and this has been replaced by investigations. So this means that investigations are really a key element when we talk about enforcement of GDPR. Those who know me know as well that I tend to be very open and transparent when it comes to the way how those investigations are done, for the simple reason that I think by doing this we can focus more on the content and less on the way those audits to happen, because there's absolutely nothing secret how these investigations are done, and I think it's also important for you to get comfort in the way we work, so that we can talk about data protection instead of procedure. So when it comes to the structure of investigation, so investigation, that's the main label that we use, but in fact we have 4 types of investigations. First of all, we make a difference between what we call on-site inspection and audit. So what's the difference between those two? Well, on-site inspection, that's a procedure that we apply if you would like to check something very specific, and in general we do this non-announced. An example would be presence of a video surveillance camera, would be the fact on how long is the retention period of some data, is some data still existing or not. So this is typically an investigation where we come, we do a spot check, and usually we have everything we need to conclude. On the other side, we have audits, which are more governance audits. A governance audit, it's typically something where you cannot just make a black or white assessment, because you need to do some balancing, you need to have more insights into the complexity of the business where an organization is in. Typically, a DPO, the assessment of the roles of a DPO, that's not something where you get in, you say hello, and you know if the implementation is right or not. No, you need to get in, you need to understand the structure, you need to understand the way they are working, what they are processing, the way they implemented the role, and so on and so forth. So that's an audit. So that's on the one side, the very specific investigations and the broader investigations. On the other side, we make a difference between what we call proactive investigations and reactive investigations. A reactive investigation, it's probably more straightforward. It's usually based on a complaint. So someone lodges a complaint with us. Let's assume we do not manage to deal with the complaint in a standard way, or we think there is reason to believe that the organization is not completely honest with us. Then we act upon a complaint. So we are reacting on something which happened, or which at least someone pretends that happened. Meaning that the scope is rather clear, because we try to achieve a solution on a complaint with the aim of this investigation. On the other side, we have proactive investigations. A proactive investigation, it's something where we, as the commissioners at CNPD, think it's important to check upon. And for me, it's very important to keep this proactive element, because otherwise our whole strategy for enforcing GDPR will just be pushed by some external factors, while we believe that as commissioners we still have some valid input in defining some elements which we would like to be checked in a proactive way. So proactive means, as Commission, we expect this to be a topic where we would like to get input, we would like to get insights, we would like to know how organizations deal with a given topic. So my presentation of today, I will focus on proactive audits. So not reactive on-site inspection, but proactive audits. And I would like to illustrate you a bit the process on how this works, so that you can understand on what is important to us and how we work. So in this context, I'm also happy to be able to announce that our Règlement interne, as well as our Règlement enquête, which are two documents that are mandatory for CNPD, also for transparency reasons, and they have been adopted by the Commission last week, Wednesday, I think was 22nd, and they will be published. So you will have access to the way CNPD is internally organized, and you will have access to a second document which explains the way we handle complaints in a more formal way within the Commission. And I think it's pretty much what I will explain you here, but it gives you more clarity because it's formal documents that you can use. So it all starts with the decision to do an audit. Now, if we talk proactive audits, as I mentioned, we think it's important to get insights into something, but we don't decide this just because one funny day we think DPO is an interesting topic. We need to allocate resources to topics where we really think that they have an impact, and the way we do this is it's through a risk assessment. So we have a look at GDPR, and we made an internal risk assessment to identify those elements. If they are not working correctly, they will have a big impact. And the DPO is clearly something where we expect, if the role of the DPO is not implemented correctly since the beginning, this additional protection that for some organizations is mandatory, if this is not working effectively, we have a risk, because not only he's not working correctly, but also other stakeholders rely on the fact that there is a DPO, which is even worse. So we expect, we assessed the risk of a wrongly implemented DPO as being of importance. The second key element that struck us when we choose this topic was the fact that obviously those organizations who have an obligation to have a DPO tend to be the larger organizations, and at the same time those who tend to process more data or more sensitive data. So it made sense also to us within this proactive approach to first go and see those organizations that do processing on a larger scale, rather than focusing on the SMEs where maybe the scale of the processing was not so high. So those were the two main reasons why we choose this topic as the first one. An additional argument was, of course, also the fact that guidance on the DPO existed since a while. We always said that if we do proactive audits, either we do it because we know that guidance exists already and we expect things to be rather clear, But if no guidance exists, then our approach might be a bit different, but still proactive audit might be a way for us to get insights. So that on the choice of the topic, we validated this choice. We thought it would be interesting to execute this same audit on 25 organizations for 5 different sectors, for the simple reason that we wanted to have the possibility to some benchmarking, because also for us, it's not easy to come to a conclusion based on a sample size of 1. So you need to get more input, you need to be able to compare practice to understand a bit the sectors, and hence the 25 organizations that we choose. So once we choose those 25 organizations, the selection process was rather mathematical, I would say, so absolutely neutral. We took the different sectors, we took the size in terms of employment, and we pretty much took the top 5 of each sector, so there was no deeper process than just fixing those two criteria. What we do when we open an investigation is that we define one of the 4 commissioners as being head of investigation, which for those 25 investigations was me. So I was head of all 25 DPO investigations, and what I do then is to define 2 case managers for each audit. In general, we work with teams of 2. One is more a staff member who is experienced in audit and or IT systems, and the other one with more legal background. Because in general, the topics are heterogeneous, so that's how we would like to mix the teams. Then we come to the internal preparation phase. When we say we open an audit on the topic of DPO, that's nice. It's mainly Article 37, 38, 39. But that's not something really auditable. So you still need to transform those obligations from the DPO into some meaningful audit objectives. So that's work that we do internally. We defined 11 audit objectives. I give you the list, but we can get back to the different objectives maybe at the later stage, because then I can give you some points for attention for the given objectives. So just to give you some examples, we would like to obtain assurance that the missions of the DPO do not lead to conflicts of interest. One very interesting one was we would like to get assurance that the DPO has sufficient resources. We would like to get assurance that the DPO provides advice to management and staff, and so on and so forth. So I will go through the list later on. Again, there's nothing secret about those objectives. So we prepare those objectives, and then we compile a preliminary questionnaire, which we send to the organization to get some first insights into the way they work. But as you can imagine, we don't ask the question, are you compliant with Article 37? Which I would say would not give very insightful results. So what we would like to do with this questionnaire is really to understand what you do, what kind of data are you processing, with whom are you working, how do you contract with subcontractors, for example. How is your organization structured, and so on. So it's rather open questions, and there's no right or wrong. So if one day you receive a questionnaire, it's not a trick, just the questions are open, because they are for us a means to understand how you work. It's not just are you compliant with. So once we have compiled this questionnaire, we send it out. So that's the first point where you get the information that as an organization we started an investigation. So you receive a letter with this preliminary questionnaire and some additional explanation. If such a letter, nothing bad happened, because it might just be a proactive approach from our side. So don't get nervous, it might just be absolutely random that you fall into the sample. Also, you might get this letter weeks or maybe even months after the formal decision was taken to open the investigation. We will inform you on the date where we took the decision to open the investigation, but that's not the point in time in regards to which we do the audit, because we need to prepare the audit. So we take the decision, then we prepare the audit, and then we send out the first questionnaire. The point in time which is important for you is the point in time where you get the letter with the information that we opened the investigation with the objectives on what we would like to check. So don't get nervous if you receive a letter today stating that we decided to open an investigation a couple of weeks ago. That doesn't matter for you. What matters to you is the point in time where you are informed of the audit. So from that moment on, fieldwork starts. We will have meetings. We will explain you what we need. You will explain to us how you work. And in general, that happens in a very constructive way. For the moment, we were not facing real issues in terms of transparency and constructive discussion, so I really hope that continues in this way. At the end of fieldwork, what we tend to do is to produce an audit report. So what is the aim of the audit report? The audit report for us, it's a way to agree on the facts. So for each objective that we defined in the audit, we would like to have a factual description of what we saw and what might need to be discussed a bit further. So it doesn't state, an audit report will never say you are in breach of. It will just say we noted that. And besides that, there will be a column with mitigating elements, which might be additional elements to consider when talking about this fact. So an audit report is not a legal qualifications. It's not a list of breaches. It's a list of elements where we think we might need to go deeper, or we might need to agree on some elements. So, which leads indeed to the question on how we do these assessments. So, I take an example. We had one objective, which was to obtain assurance that the DPO has the required level of expertise and competence. So that's something we would like to check. Internally, we gave ourselves a benchmark. So we said, okay, if the DPO, let's say, has a master's degree in data protection, he has an engineering degree in IT, he's the guru in banking, and he's the DPO of a bank, then we would be happy and we would not go further. So the benchmark was not that high, but still, we fixed the benchmark and we said, if we see this situation, we are happy and we go to the next topic. If we don't see this situation, that means that we expect to go a bit further. It doesn't mean that you're in breach. It means we would like to know how you address the situation. I take the example of the expertise of the DPO to illustrate. You might very often you have DPOs who have a lot of expertise in legal or in IT, but not so often in both areas at the same time. So there is some mitigation to be applied. And typical mitigation elements that we saw was that there was a DPO office. So it's not only one DPO, but the DPO works in a team. And the DPO office has multiple staff, one with IT background, one with legal background, and one with marketing background, for example. So that's one mitigating element that we saw. However, to consider this as being a sufficient mitigation to still achieve the objective, we expect this DPO office to really formally exist. So it doesn't mean that the DPO is working regularly with the head of IT. No, I mean, if you would like to say, okay, our DPO does not have a master's degree in legal and is an IT engineer at the same time, we work with an DPO office, then we expect this DPO office to formally exist in the organizational chart with staff that actually has those competences. Another mitigation that we saw very often is that organizations rely on external advice. So the DPO has some competence, and they complete it with external advice contracts that they can call upon. Again, this is something where in some instances we do expect this to be sufficient. However, one of the conditions is again that the DPO has free access to this external advice. He doesn't need to apply for budget to get hands on this external advice, and we would like to make sure that it's not the same legal advice that is also representing the organization. So we have the DPO who should represent the interests of the data subject, where legal in general represents the interest of the organization itself. So you can rely on external advice. So this is something which is acceptable for us under the condition that, first of all, this access is direct, and secondly, it's not the same legal advice that you use to represent the organization, the interest of the organization. So that's how it works. So for each objective, we fix the benchmark. If we are not happy in the first place, we dig a bit deeper, we document what is in place, and we document the mitigation elements that might help you to justify the fact that the objective is still achieved even though the initial benchmark has not been achieved. So now in regards to the objectives, I will give you the objectives, but I will limit myself to the most important advice that I can give you. Because I have 5 minutes and I know that everybody wants to have a coffee and I don't want to be the one who holds you back from coffee. So first objective, we wanted to get assurance that those organizations who have an obligation to designate a DPO did designate a DPO. I will just 2 words on this. Please document the assessment if you don't have a DPO. It's evident for us that this assessment is important to have a justification and to being able to challenge it. But I would also recommend you to document it if you have a DPO, because it's still an indication for us that the day where the DPO is no longer, the position is no longer occupied, that we have formal proof that the position should exist. But it's more important that you document the assessment if you decide not to appoint a DPO. And also, please be aware that DPO, it's not a hat you give to the last one who enters in the morning. For us, it's a real role. And as I mentioned, it's a very important role for us. Otherwise, we would not have identified it as a high risk if the role is not implemented correctly. So if we have the feeling that the DPO is just some random person within the organization to fulfill the requirement to have appointed a DPO, we might not be happy. Second objective was to obtain assurance that the organization published the contact details of the DPO. So we make the difference between internal and external communication. Internal communication, it's in regards to the staff, so that your staff actually knows that there is some contact point within the organization who is in charge of data privacy, but externally also to make sure that the data subjects, which are very often external to the organizations, except for those who are in a purely B2B business, so that those people are also aware that there is a DPO. Internally, we definitely expect a positive action, which means some positive communication, not something which you can find somewhere in a policy, somewhere on the intranet. We expect a positive move from management to say, please, dear staff members, we have a DPO, it's this person, and he's in charge. Externally, one can have a discussion if you need to positively, actively contact everyone, or if maybe a more passive approach is suitable as well. We also make the difference between the one-shot information and the, we call it business as usual. We know that when, shortly before GDPR, there was a lot of one-shot information or projects, I would call it. So a lot of information was spread at that point in time. But I mentioned it earlier, GDPR was just the beginning, and even after GDPR, people who join an organization need to be made aware of the fact that there is a DPO, what are his roles, and so on. So don't forget the fact that you need to keep this information up to date. Third objective was obtain assurance that the organization has communicated the designation of the DPO to us. I will skip that one. We have forms on our website. Please use the forms. And please be aware that we actually use the contact details of the DPO. So if in the meantime your DPO changed, you did not inform us, the day where we have an issue, we will just contact the DPO you designated with us. If this guy is no longer working with you, I would like to avoid accidents that we contact the DPO to talk about maybe a data breach and you forgot to tell us that he's no longer working with your organization. So please be aware that the contact details you provide to us are important and they will be used. The fourth objective was the DPO has the required expertise and competencies. I already explained a bit more in detail in regards to our expectation when it comes to mitigating elements. The fifth one was obtain assurance that the roles of the DPO do not lead to any conflict of interests. So our expectation was that we have full-time DPOs, but there were mainly larger organizations, so each time where the DPO was not a full-time DPO, we wanted to dig a bit deeper. We were very active in insurance and banking, so the question of AML KYC came up rather often, and I must explain you that we have some elements to deal with when it comes to the fact that the head of compliance or the head of AML KYC is at the same time DPO, that there might be situations which are not very lucky, which need to be mitigated. I don't want to go into the details of those mitigating elements that can be used. The sixth element was obtain assurance that the DPO has sufficient resources. And how should I say? It's a very tricky question because it also depends. In order to state if a DPO has enough resources, you need to understand how he's working and who is supporting him. I explain myself. If you have a DPO and the DPO, now I will not talk too much on DPIA, but if the DPO needs to do all the DPIAs, he needs to handle all the data breaches, he needs to do all the training, he needs to do everything, it's a bit complicated to say that that's first of all the way it's supposed to work, and secondly, safe to say that he has enough resources. So one important question when talking about resources of a DPO is to check that he's actually working the way he's supposed to work, meaning he should provide advice. He's more in the second line of defense than in the first line of defense, which gets back to the question with whom he's working. So we saw a lot of situations where the DPO has points of contact which are the heads of division of the different business lines. That's okay. I mean, those are very relevant people, but don't consider the head of a business line as being support to the DPO. He's absolutely not independent. I mean, it's a very good point of contact to get insight, but don't consider those people as being like DPO biz, like they don't have the independence when they need to assess their own business line. So what we tend to say is that make a difference between having a point of contact who can provide insights in what decisions are taken and maybe an independent point of contact who can really provide work or who can support the DPO when he's doing his daily work. So the seventh objective was to obtain assurance to what extent the DPO is autonomous in the execution of his work. I will take a shortcut. What is important to us is that there is ways in place where the DPO can escalate in case he feels not being fully autonomous. And don't put in place those escalation mechanisms the first time you need to use the escalation mechanism. An escalation mechanism should be in place before, because once you are in a litigation or once you are in a tricky situation where a breach happened, that's not the most appropriate moment to discuss on how the DPO can escalate towards management. You need to put it in place before, so that once it's needed, you can just execute it. Objective number 8 was the fact that the DPO must be associated with all data protection related questions and activities since the beginning. So we expect the DPO to assist in EXCO meetings, to assist in steering committees, or at least that he has the freedom to join those meetings even if he's not formally invited. Objective number 9 is to provide advice to management and staff. And there, again, it's very important to understand the way this happens. The DPO can do the training himself, but he can also rely on other sources to provide this training. Objective number 10, compliance. The DPO is monitoring compliance on processing activities, and that's an important one because we need to get into a business as usual. I would say compliance is maybe a bit more advanced in terms of maturity because they are used to the fact that rules exist, but if you don't do a systematic follow-up, if people do comply with the rules, they tend to be forgotten after a while. The way compliance with processing activities can be checked is typically through a compliance and audit plan, but we expect some formal structure to exist to being able to demonstrate to us that there is follow-up on the respect of the rules. And the last one is to obtain assurance in the fact that the DPO is assisting management during the DPIAs. And I underline assisting management during the DPIA, not necessarily doing the DPIA, because this might put him into a tricky situation later on. So those are the 11 objectives. We state in the audit report on each of the objectives. If we have some something to dig deeper, we put it together with the mitigation elements, and then we agree on the report. The next step is the statement of objections, which indeed is then the legal qualification of the content of the report. Based on what we have in the report, does the head of investigation think that some rules of GDPR are not complied with? If this is the case, there will be a letter stating in a very clear way, based on this and this fact, we think that you are not compliant, and we will list again the facts that we came across. We will send you this letter, and you will have the possibility to take position on this letter. So that's the right to be heard, the contradictoire in French. So you will have, once again, you have the possibility during the report, but you have once again the possibility after having received such a letter of objections, the possibility to provide additional elements, which might not have been taken into consideration during the audit field work, and you are in the position to express your point of view in regards of this objection which has been raised. So you will receive this letter. Typically you will have 30 days to take position. Once this is done, the head of investigation will, in general, transfer the file towards the other 3 commissioners, and they will fix a date on which there is the presentation of the case in front of the 3 other commissioners. You will have the possibility to be present. So typically I will present to my 3 other colleagues the facts, the objections that I came across. So I will explain the feedback you gave in written form after the letter of objections. If you want to be present, you can be present. You can present yourself your point of view in front of the 3 other commissioners, and then there will be a decision on the outcome of the audit after that meeting. So I hope I was not too long. I was too long, but I hope you still have the time to get
only very, very, very few minutes. But I think we can still have a few more minutes for questions. Are there any quick questions in the room? Quick. Yes.
Thank you for your very informative lecture. I think it was very important for all of us to hear what you had to say. My question is, is there some incoherence today between KYC AML requirements and the data protection rules? When I say AML, KYC, bank secrecy, professional secrecy, and this volet of data protection. Do you perceive that there is some incoherency between those 3 bodies of law?
not say incoherence, I think it's different topics with a different perspective in mind. I mean, when we talk about privacy, we talk about being as privacy preserving as possible, while AML KYC checks, they are not executed for the well-being of this given human being. They are executed because there's an overall interest in having a transparent, to avoid financing of terrorism and so on. So the activities that you do in AML KYC, that is background checks to avoid some people getting financed. So of course, this is not the same objective than keeping people's data private. But this being said, it's also an important objective of our society to avoid financing terrorism, so we need to find a balance. And that's what I would like to stress out. The DPO has as a primary objective to make sure that data privacy rights are respected. The one who is in charge of AML KYC has as a primary objective making sure that AML KYC obligations are respected. As those two objectives might need some balancing at some point in time, we would like to bring to attention that if someone has responsibility for both, he needs to do an assessment between both, which is to some extent putting him in a conflict of interest. So he needs to balance something where he needs to choose if he gives priority to data privacy or to AML KYC.
Thank you. So, thank you again. And then I would like to welcome our next speaker, who's Vakil Borzakdali. He's legal officer and data protection consult at MGSI. And he will speak today about data protection by design and by default, and data protection impact assessment.
Hello everyone. So as you can see, I'm Vakil Borzakdali, and the purpose of this presentation is data protection by design and by default, and data protection impact assessment. So we are gonna speak quickly about the difference that can be between the concept of data protection by design and the
Can you speak up a bit?
Okay. Okay, and the data protection impact assessment. Also, the risk-based approach is not specifically mentioned in the GDPR. The concept of risk runs throughout the GDPR. Here are some examples. Article 25, taking into account the state of the art, the cost of implementation, nature, scope, context, and purposes of processing, as well as the risks. Second example, Article 32, security of processing. Taking into account the state of the art, the cost of implementation, nature, scope, context, purpose of processing, as well as the risk. Third example, where type of processing, in particular using new technologies and taking into account the nature, the scope, context, and purposes of the processing, is likely to result in a high risk. So, in determining whether an activity is risky or not for data subjects, it's important to conduct risk assessments by, of course, reference to the state of the art, the scope, context, and purposes of the processing. It's obvious that when an organization processes personal data, there is risk regarding the personal data which are processing. So here are the main obligation of the data controller. Of course, he needs to secure the processing and to implement appropriate technical and organizational measures. There is the data protection by design and by default, which has been a core concept in privacy management for a long time now. Article 25 has codified that. We know, security professionals know, that it will be lovely to be involved in the first conversations about a new project. Article 25, of course, has codified that. The idea where you're designing a new project, just you want to launch a new project, you need to think data protection at the earliest stage. So here are the obligation of the data protection by design and by default. The controller needs to take into account the data protection principle from the early stage of a project. He needs to ensure that the security of the data throughout their life cycle, implement pseudonymization and encryption of data if necessary, restrict technically and by default data processing, and of course facilitate the effective exercise of the rights of the data subjects. A DPIA, Data Protection Impact Assessment, should begin early in the life of a project, before the processing. I do insist, before the processing. And of course, it runs alongside the planning and development process. Of course, it should include these steps: identify the need for DPIA, describe the processing, consider consultation, assess necessity and proportionality, identify and assess risks, identify measures to mitigate the risk, sign off and record outcomes, integrate outcomes into a plan, and keep under review. Do not forget that a DPIA is an iterative process. So the goal of data protection impact assessment is first a process for building and demonstrating compliance with the GDPR. It helps organizations to identify the high risks of the concerned processing. Of course, it helps to identify the appropriate measure to mitigate or contain the risks at an acceptable level. As said, it's an iterative process. Each of the stages is revisited multiple times before the DPIA can be completed. And of course, the processing needs to be approved before the processing itself. The data protection by design and by default, which is a broader concept, if a DPIA is mandatory, the measures need to be implemented throughout the entire data lifecycle. If no DPIA is mandatory, we need to identify the risks and the appropriate security measures too, at the time of the determination of the means for processing and at the time of the processing itself. So let's have a quick look to the different steps of the DPIA process. So the first one is the first step, initiation of the project. For all the projects, for all new projects, linked to data, personal data or not. So the first question that we can ask, why this project? Is it feasible? Who are possible partners in this project? What should the results be? And of course, for our purpose, are personal data involved? Okay. Yes, there are some personal data. Step 2, step of identification of the risks. And we need to think about the organizational and technical measures. And of course, at that time, we need to do a DPIA threshold assessment evaluation. In other words, we need to evaluate if a DPIA is mandatory or not. We are, for instance, in the case that a DPIA is mandatory, we will realize the DPIA. At the end, we have concluded that the processing is authorized, but to the strict extent that phase 3, we need to implement and think about the organizational and technical measures. That is to say, the processing is authorized, but we need to implement the good measures, the appropriate measures to mitigate or contain the risks. And of course, we will do some spot check just to know if we are still under control. A lot of. And the final one, of course, needs the approval and, of course, the requirements of the actions asked by the DPO. And at the end, the final check, we need to, is this processing still authorized? Of course, we need to understand for new technologies if a new functionality has appeared during the project. And then, phase 4, we can go to the processing, the go live phase. The data protection by design by default process is more, let's say, more easy. The first phase, the same phase as the DPIA, initiation of the project. We will document the project and the processing. Then a DPIA threshold assessment is necessary too. Okay, no DPIA required. Phase 2, we need to identify the risks and think about the organizational and technical measures. And phase 3, implementation of those organizational and technical measures. Then it's okay, can go live. And the phase after, throughout the entire data lifecycle, we need to reflect, we need to understand that the private data protection by design, by default, sorry, is a broader concept which applies to the whole organization. So, conclusion, we have understood that the DPIA is an integral part of the data protection by design and by default. But today, if a DPIA is mandatory for organizations, it means that we are facing high risks. That's totally true. That's totally true. So when a DPIA is mandatory, we need to implement a high level of security. That's true. But when a DPIA is not mandatory, the data protection by design by default apply to the whole organization. And we can say that we can put standard level of security because no DPIA is mandatory. And unfortunately, that's a mistake. A lot of organizations has considered that when a DPIA is not mandatory, it's also standard security level. Okay, it's enough. No. The risk-based approach in the GDPR say you need to put appropriate technical and organizational measures, which could be the same as if a DPIA was mandatory. DPIA is an integral part of the data protection by design by default, but it's not because the criteria of Article 35 and the list established by the Data Protection Authority are not met that we can say, okay, standard security level is enough. That's not true. Thank you.
So, welcome back, everybody. I think everybody has found a seat again. So, it's an honor to me to present you now Steve Müller. He's a cybersecurity specialist at BeSecure. And today he will talk to us about privacy for everyone and will present you some practical tips.
So, hi, everyone. I hope you can hear me. I think you. So, I'm Steve. I'm from BeSecure, the Cybersecurity Awareness Center of Luxembourg. I'm not sure if everyone knows BeSecure. You should. So our mission is to raise awareness about risks and opportunities of the new technologies, as people call it. Our mission is also to explain these technologies to people. And to that end, we also get a lot of trainings. We go to a lot of conferences. For instance, we have over 1,000 trainings to students and parents and teachers and youngsters and elder people. And I was asked today to talk about privacy. Well, privacy is obviously one of our topics. But then I said, what can you possibly tell those people that you all know something about privacy. We heard a lot of, let's say, organizational privacy today. And well, the first thing that came to my mind was these two cliches of people. One side is the guy that sees secret services everywhere. You can actually buy that shirt, by the way. And the other are the people who say, well, I have nothing to hide, so why should I care, and just post everything on Instagram, Snapchat, and so on. Well, that's true. Why the big differences in opinion? I explain that by an analogy. For instance, this is my car. No, it's not. And I mean, we all have cars. We all have people that drive our car except ourselves. And the question is, our cars, which are highly valuable to us, would you also let other people drive it? For instance, your friends. Well, I hope you would, but I mean, literally all of your friends. Would you let a hitchhiker drive your car? For instance, if you have a long way to drive and you're super tired, would you let the complete stranger drive it? Probably not, but some people actually would. And friends of mine, I know some friends who also do hitchhiking, and they let people drive their car without any problem. Now, why is that difference in mind? Well, there are two factors that influence our decisions there. One is trust, and trust is also a core component of GDPR, which enables us to kind of rely on other people. But I don't want to go too much into detail here because it's a very subjective one. And the other factor is experience. So the experience we made by, let's say, already driving other people's cars. And experience is something that's a bit weird, because what is experience? Experience, we have experience means we know the consequences. We made those already. And lack of experience often lets us take irrational decisions, like, yeah, I don't know strangers, I don't want them in our country, but this is a complete different discussion. The whole discussion is, though, true also about our personal data. I give you a concrete example of everyone's life. So this is a real screenshot I made, I think, a week ago of some, well, online magazine. What's the first thing you see? Well, you see a lot of advertisements, navigation, that famous cookie banner, and actually what we're interested in, you can't even see it, you only see the heading. So is this the privacy we wanted? Probably not. Now, why in the first place is this cookie banner anyway? Let's have a look at what it says. It says, well, DMG Media, whoever that is, uses cookies and other technologies, well, this is very transparent, is it? To deliver content and advertising. Okay, yeah, what is my choice? Well, I can adjust settings and I can say, yeah, I'm fine with that. So question to the audience, who just clicks on got it? I must say, meanwhile, I do it as well because I keep getting annoyed by those. Who just continues browsing without, I mean, just ignoring this banner? Some are. Who adjust their cookie settings? Oh, there are a few, okay, idealists in the room, that's good. I wanted to focus a bit on this idea, what actually is that cookie and why are they displaying it, that message to us? So I hear people a lot speaking about cookies, but no one really seems to know what it is. So I suppose you all have been to concert already, or festival, and when you enter the concert at the box office, you usually get one of these wristbands. What's the wristband for? Well, it is that you can leave the campus, and when you return, and security knows, oh, that guy has been at the box office already, so they don't need to check you again. And basically, a cookie is exactly one of these wristbands. So when you're on a website, say PayPal, for instance, and you log in, you provide your username and your password to that, you click login, it will send the request to the server, and the server will get you a cookie, so a wristband, basically. The server checks your password, it knows, okay, you are that person, and it gives you a cookie. The difference to a normal wristband, maybe, is that the wristband is kind of anonymous. A cookie needs to be specific to you just because, well, the website wants to know that it's really you. So especially for online banking, this is interesting that you actually can only see your own account and not another one's. So what does your browser, for instance, Firefox, do? Well, it stores that cookie for later use. All of this is completely transparent to you, so you don't see any of these. Now, the next time you visit, in this case, PayPal, and you click on that link, Firefox will check if it has a cookie for that site. Well, in this case, it does, and it sends it along with the request so that the server knows, aha, that's that guy that I've faced already, and it can automatically log you in, kind of display your balance, which, as you see, is not a lot for me, but whatever. And this happens actually for every button and every link you press on this page. For every link and every button, it will send again that cookie so that the server will recognize you. Now, this is all and good, but I mean, why the big fuss about privacy, right? Let's go back here to that site again. It's not only used for login, and that's where the whole discussion comes about. Every ad, for instance, on this page will also give you a cookie. What's the point of that? Well, when you're on this website, the advertising company will see that you're reading something about worst inventions ever. I don't know why I opened this article, but whatever. Now the advertising company will give you a cookie so that it will recognize you once you're on a different site where again that ad company is present and also showing advertisements. And in that case it will know, aha, this guy, I've seen him already. Last time he was reading something about worst inventions, this time he's reading something about cars, and maybe next time he's reading something about, I don't know, microelectronics. And that way they can kind of trace you down. That's the famous tracking that everyone is talking about. It's that profiling your interests kind of. What's the point? Well, advertising companies are highly interested in what you're interested in because that way they can present you advertising that's really relevant to you. The chances that you're clicking on the ads are higher and that means more income for them and so on. That's the whole point. Now the problem of all of this is that we don't see any of these. And this might lead to discrimination, as I've shown, for instance, the Cambridge Analytica scandals, where they even did political influence through advertising and through social networks. Some of you might have checked already flights online, booking flights. The longer you're searching for flights, the higher the prices will get. Surprise. Why is that? Well, they notice that you're actually comparing. And well, when they see that you're comparing prices, they say, yeah, let's maybe just not propose our cheapest prices to them. So this is all kind of things that we don't really want to. And I just give you some advice on how you can stop it. I mean, the tracking, stopping the tracking, that's task of GDPR. What can you personally do about it? The easiest thing is, well, you click on that banner, go to the cookie settings, and in the best way, they will present you something like this, where you see you can disable these cookies. Well, the first one, the necessary cookies, you usually can't disable them. These are used for login, for instance, or language selection and so on. But the second one, you say analytic cookies, they are mainly used so that the website can kind of check what sites you're on. The last one is interesting, marketing cookies. Functional cookies, no one really knows what they are, so better just disable them. There are also websites where you cannot just easily disable that. This is a mess, but hey, it's GDPR compliant, so it's fine. Another thing you can do is you go to your browser settings and you can delete the history. Deleting the history also gives you the choice to delete cookies, as you can see right here. That does not stop the tracking, but it kind of destroys the connection between your cookie and your computer. So the next time you visit a website, it will not have a cookie anymore, so you get a new cookie and the profiling starts over and over. Of course, what you can also do is just block ads. That's, I mean, ads are responsible for, let's say, 90% of the tracking already. And the last thing that's interesting, it's the famous private window or incognito mode, sometimes also called porn mode for reasons that I don't know. So what's the private mode? The private mode is basically a normal window. When you open it, you can do the normal stuff you can also do. The only difference is that once you close the window, it will destroy all activity that you've been doing in this window on your local computer. That means it will delete the history that you made in this window and delete all cookies that have been created while you were in this window. In particular, it means that it does not block the tracking. You're still tracked, but after the window is closed, the tracking is kind of disassociated from you. It's interesting here because people sometimes don't want to clear the history. As I do, I want to know today what sites I've been on yesterday because I forget everything. But sometimes, for instance, if I check flights, I still don't want cookies to be saved. Okay, so this is pretty easy. Especially when we talk about tracking information, this is basically all the discussion that's about tracking information on computers. It's mainly websites we visited and our interests. the whole discussion normally does not include the real tracking information that's available nowadays, especially on our phones. On our phones, well, what data can you get? Our phones know when we're busy. Our phones know who we talk to. They know how we look like. They know where we are, and so on and so on. Now, it's a bit naive, I think, to believe that this information is not used by advertising companies. Surprise, it is. So what kind of information can you do? So there was a kind of a rumor about an app called Talking Angela. It's a cat. It's an app for kids, I believe, but whatever. And that cat, well, you can talk to it. It will reply using some kind of artificial intelligence. And that app also required access to your camera. And then people started wondering, well, why? I mean, what's the point? And there was a whole rumor about, yeah, people watching you through, apparently you could see some stranger in the eye of the cat or in the mirror. It was really, well, weird rumors. There were no evidence that this actually happened, that people were surveilling you through the app, but of course, technically it would have been possible. You gave the permission to the app that it could do that. It could theoretically send it to the servers. There are some apps that are real problematic, like this one. It's a flashlight app. Well, no problems, right? It's pretty innocent, except maybe that it says it contains ads. Well, okay, that's not really surprising either, because a lot of free apps just finance themselves with ads. The problem with this app is that actually when you installed it, it was no longer visible. You could not see it in the list of your apps. It could not see it on your home screen. What it did is it just opened your browser every 5 minutes and displayed you some advertising. Now, if you know that you installed this app by yourself, then you probably can make the link and delete the app by yourself. But if you don't know that, then you just see random advertising for no reason. Now, why is that the case? The problem here is that we see that in a minute, permissions are not often not really considered by people. They say, yeah, okay, I just give permission, it's fine, right? You can also install real spyware. This is usually not available in the App Store. It's what parents install on their children's phones to know where they are, who they write to. I purposefully just blur the names of the apps because I know that there are people just keeping note of the name. These apps are not only illegal, they also are a really high risk for your phone, because these apps have, I mean, really like administrator rights on your phone. And believe me, these apps do not only give that data to the parents, but also to the maintainer of the app. So it's a bit risky to just install that on your phone. Now, I'm bashing here on all kinds of usage of data. I also want to give you a positive example. Data is not only used to track on us, but for instance, Google, in particular Google Maps, they also use the location data of our phones and also the speed of the accelerometer to know where traffic jams are all over the world. So if you ever wondered how Google Maps had this information, it's all of us who is providing this information to Google. And this is fine, right? I mean, it's completely anonymized, so in terms of privacy, it's fine. And also we get that data back for free. I mean, no one is paying for Google Maps. So that's also pretty cool. The question that one may ask then is, well, what data actually do we want to share and what data don't we want to share? And the very related question to that is, well, who is our threat? And I have the impression that the whole discussion is always about, yeah, secret services and companies spying on us. Well, it is obviously true that if a government sets up like a surveillance program like they do in London right now, it's probably not the best way to go. And I completely agree with you on that. Same companies, I mean, if you think about booking flights online, this is definitely not fair use of data, but the real threat is criminals. Criminals who abuse of your data to steal your identity. I mean, you can buy a fake identity or real identity online for $80 or so. So this is your real threat. They try to capture phones in order to launch large-scale attacks against companies, governments, and so on. And one interesting point as well is, you say, yeah, family, colleagues, they're friends of mine, they will never harm me in any way. Believe me, we at BSecure have a lot of problems with stalking and mobbing and sexting and grooming cases. The threat often comes from, your environment. So I'm not saying that you should hide everything from your family, but believe me, you don't want them to have a camera in, let's say, your apartment, just for the case if you have a fight next time, the camera won't help. So just think about that. One note I want just to make here, because I see a lot of people who do that, just for your own sake, don't jailbreak or root your device. Why is that? If you root your device or jailbreak it for iPhone, then you can install apps like the flashlight lab that I showed you before. It's basically disabling a security mechanism on your phone that guarantees that the permissions that you give, the screens that you say, are really the only ones that an app has access to. If you jailbreak it, an app can ask, any right it wants. Same is true for app stores that are, not the official ones. I'm sure you know Fortnite. Fortnite is a game that's often used by small kids, played by younger kids. And they have problems with the official app store because they need to pay 30% commission to them. And they say, why should we do that? If the people just buy it from us directly, well, then we don't have to pay that fee. So what they did is just they withdrew the app from the app store, and then they invited people to download it from their app store on their website. The problem with that is, of course, that you need to kind of do exactly that. So allow apps to be installed from other sources and make your phone vulnerable to like these flashlights app. The recommendation I can give you here, if you really want to, and believe me, it's hard to convince a child that he cannot play his favorite game. Make sure that you re-enable the security by just disabling the allow from this source setting. Okay. Speaking of settings, as I said, if you don't kind of circumvent all the security measures that the phone provides you, this is the only way that an app can have access to your data. And there are two ways to check it. One is you go to your settings. At the very bottom, you see a list of apps. And if you tap on that, you will see all the permissions that it has. And as you can see, you can also withdraw info permissions, which I can recommend you to do. Same on Android, for instance. It's a bit more complicated, but Android tends to be more complicated. And as you see here, for instance, I withdrew WhatsApp the access to my contacts, because I know WhatsApp is in link with Facebook. I don't want that Facebook knows who my friends are, except those that are explicitly add on Facebook. This is a personal matter. It's not something that I ask you to do, but it's nice to know that it's possible, right? There's another way to see things. So this is kind of to see what permissions an app has. If you want to know what apps can access, for instance, your contacts, you can also do that. It's hidden in the privacy menu. There you see the list of permissions, and you can say, who has access to my contacts, by the way? And this is a good exercise that you can do. Just go to your phone and just check, the different permissions. Who has access to my contacts? Do they actually need that? And in case of doubt, just disable it. If the app doesn't work anymore, well, you can re-enable that at every time, right? Just for completeness, same thing on Android. Again, it's a bit more, it's a longer way down there, but it's also available here. Now, we missed an entire category as well. So we're talking about computers, smartphones, but there's a new kind of class of devices that's available on the market. It's the so-called IoT, smart home. These devices have the same sensors than our phones have today. But what's different from these devices? Well, one thing that you need to know is that it's not the case that you install an app and it will directly control your device. You say, well, of course I need an internet connection, so it will probably go over my Fritzbox. But surprise, this is also not the case. It's a bit more complex than that. Now, to understand this, we have to go a bit on a larger scale. In fact, it's not your phone who is controlling it, but it's a server. The server is the server by the manufacturer, and as manufacturers, often American or Chinese. Well, the servers are also in America or Chinese. Just a hint in terms of GDPR, this is outside of Europe. Exactly. Now, why do they do that? Why don't just your phones control the devices? Well, it's for the only practical reason that you're not always at home. For instance, you're on a way at work, you might be somewhere abroad, and you might still want to control the devices. So I have no idea. I don't have that need to control my devices from abroad, but apparently someone had the idea, hey, that would be nice, whatever. It's like this now. And the reason, the functioning here has two implications actually. One is, well, if they decide to drop the support from your device, well, then the server doesn't exist anymore and your app won't work anymore. And then I just hope for you that your device has a button on it where, for instance, for the vacuum cleaner, that can actually activate the vacuum cleaning, because otherwise you need to throw it away. And the second implication is that whoever has access to the server as well also has access to your device. And I'm not talking about, other companies here, but I'm really talking very practically. The first time you set up your device, it asks you a password. Now, this password, many people believe that it's to protect the device from your kids, that it cannot play around with your vacuum cleaner. Well, it's not true. It's an actual account of a password of an account that you created. Whoever knows that password worldwide can also access your device. If you choose a password that's not very complex, well, you get the point, right? So what can you do about protecting your account? First of all, what people always say is choose a good password, and long passwords, strong passwords need to be long, complex, unique, yeah, whatever. Okay. What I advise you to do, why not just use a sentence? If you're, let's say, for instance, a Luxembourgish sentence, for those that don't understand it, it's, can I have a potato, please? So just some stupid sentence that you can just remember. Luxembourgish is interesting, actually, because it has a lot of accents, and accents are kind of special characters already. And also, Luxembourgish orthography is so weird that no one actually knows. So even if someone knows your password, he doesn't know how to spell it. So that's pretty interesting as well. And as you noticed, if you use a sentence, well, certainly long enough, it has capital, it has digits, it has special characters, and so on. So you automatically fulfill all the criteria. That's a good trick. Another one is, and an advice that I really need to give you, because I see that everywhere, please don't reuse passwords. Now, I know that remembering passwords is hard. I know it myself. Now, why shouldn't you reuse it? What we have seen is that, for instance, what criminals can do is they just publish an app, like a random game, these Clash of I don't know what, and they ask you to create an account for that. Well, right, you say, okay, I just use my normal email address, I'd use my normal password to log in, and then I can play. The problem with that is you just provided your normal email address and your normal password to a complete stranger, and what's the first thing they're trying to do? Well, checking if that password also works for the other sites. And this is not only true about passwords that you provided to, let's say, random apps. It also happens sometimes when there is a large data breach where criminals try to do exactly the same. You can buy on the black market a whole list of known passwords from users that got hacked for not, I think it's like a few dollars per 1,000 passwords or so. An advice that I can give you, for instance, if you have that super password, please don't use that password now. Just use another sentence. What you can do at least is add a suffix for every site. It's not perfect. It will work for all these automated checks. If a criminal gets access to your password, you're one among millions. So they use automated programs to check if that password works on other sites as well. If you have a suffix, yeah, okay, it won't work. I also give this training to teachers, for instance. This is not a good advice for teachers, because the biggest fear of teachers is that their students get their password. And obviously, if a student sees this password of yours, it can directly guess, all the others. So it's a bit, it depends a bit on the situation. Another thing you can do is use password managers. I hope that you all have heard of password managers. For those that don't, this is a selection of password managers that are free to use. they are basically an application where you can store all your passwords in. Now, what's the difference between that and an Excel file? This file is encrypted according to the latest and highest industry standards. So you are asked a master password, which you type in, and then it will encrypt all your passwords. What's also interesting about password managers, they will generate passwords for you. So you don't have to worry about choosing a password or remembering it or whatever. It will also automatically fill it in the website. And this is nice, it's practical. It's also secure because it automatically checks if you're on the right web page. You heard of phishing attacks where people try to put you on deceptive websites. Well, this password manager will check if you're actually on the correct one. Okay, for those who say, yeah, but this does not protect me from someone stealing my passwords, there is, for banks, you know that, there's this LuxTrust token, so that if someone steals your password and your username, he can still nothing do with it because he needs that token of yours, so he needs to physically steal it from you. Now you could say, why doesn't that exist for all of the other accounts? Well, it does, it's not LuxTrust. It's called two-factor authentication, and this is basically an app that you can download from the App Store. It will also produce a 6-digit code that's valid for 30 seconds, and whatever websites you associate it with, like in this case Dropbox, you just put in the code, and it provides you the same protection that LuxTrust does. These apps are available for free on the App Stores. There are several variants of those. Doesn't matter which one you choose, it's called Authenticator usually. I just advise you to try it. Now, how does it work? You just go to your website, where it's, for instance, your email account, you go to the security settings somewhere where you can enable two-factor authentication, you click on that, they will give you a QR code, and then in your app you press the plus, you scan the code, and you're set. So this is all you need to do. It's pretty simple. I just need to say that it's sometimes not so obvious to find that button where you can enable the two-factor authentication. Okay. So the message I want to give you today is that privacy is not about, and I hear that a lot, if we have something to hide, what we have to hide. It is about if we are able to hide it when we want to. And I hope I've given you some advice today, some practical tools where you can kind of get the power back to hide the content that you want. If this was a bit too fast, we have a website where you find a lot of resources, some of this, some additional one, and if you need help for implementing it, we have a an anonymous and a free hotline where you can talk to real people who are super nice and super competent, and they are really enjoy helping you on that. Thank you very much.
Thank you. So our next speaker is Emma Goodwin from the APDL, and she will talk to us about maintaining motivation in crowdsourced projects and the implication of GDPR. And there you will present a case study. You're welcome.
Hello. First of all, I'd like to extend a very sincere thank you to the organisers of Data Privacy Day 2020 and fellow board members of the APDL for the kind invitation. This October, I organised a public medieval French transcription competition at the University of Luxembourg, based on one of my digital research projects, Crowdmap-the-Crusades. And in the first half of my presentation, the first 3 sections, I'd like to share with you the results of the event in relation to the question of how to maintain or keep up motivation in crowdsourcing projects, and how we can deal with this in the context of GDPR. Now, as today is Data Privacy Day, in the 4th section of the talk, I'd like to consider GDPR more broadly in the context of research data, data analytics, machine learning, and the Internet of Things. The penultimate section is a more practical approach to planning academic projects and whether the data you intend to collect falls under GDPR. And I'm going to conclude with a few proposals about how we might draw some inspiration from GDPR when engaging critically with research questions. So to begin with, I want to look at what is crowdsourcing. I've got 3 definitions up on the slide. Today I'm working with the first and the third definitions primarily. The first because it's succinct and applicable to all crowdsourcing projects, and the third because it resonates with the experience of the public transcription competition on October 5th. Pausing for a moment to unpack the way in which crowdsourcing and social engagement interrelate, the idea is that crowdsourcing uses social engagement techniques to help a group of people work collaboratively towards a common goal, but relies on sustained input and more effort than just socially engaging, which may be transitory or something that happens only once. It's an important consideration for the crowdsourcing field because users want the same and more social interactions than they had in pre-digital days. An interesting development in this field in recent years ties in with the desire on the part of users to have more social interactions, and it can be seen in the use of gamification in crowdsourcing. Crowdsourcing harnesses online users to address specific problems, and the success of crowdsourcing projects requires incentives to motivate participation. Apart from volunteerism and monetary rewards, computer games are another possible means to attract participants due to the growing numbers of game players worldwide. Thus, games layered upon crowdsourcing tasks have emerged. And Mortroiser and colleagues in 2016 investigated how gamification had been used in different types of crowdsourcing and established that gamification had been an effective approach for increasing crowdsourcing participation and the quality of crowdsourced work. However, differences did exist between different types of crowdsourcing depending on whether the crowdsourcing involved homogeneous tasks or more diverse and creative contributions. The research conducted in the context of crowdsourcing of homogeneous tasks has more commonly used simple gamification techniques such as points and leaderboards, whereas implementations that seek diverse and creative contributions employ gamifications with a richer set of mechanics. I'm going to return to the question of motivation a little later on when discussing the results of the competition, but I'm now going to turn to the second section of the talk and the case study of Crowdmap-the-Crusades. This project's been going on for 6 years. It tweets out single lines to transcribe from an unpublished portion of an anonymous Old French Bodleian manuscript, Oxford Hatton 77. It dates from the beginning of the 13th century, and it's the oldest and most complete version of the text. It's 16,000 lines long, written on parchment by an Anglo-Norman scribe, and it includes one illustration you can see on the screen, which has a scene from the siege of Jerusalem, in which 2 youths are assisting 2 archers by pulling on ropes in order to catapult a cauldron of fire. The text is also corroborated in full in a 14th century manuscript in the British Library, and there are 2 mid-13th century fragments at the Bodleian in Oxford. It's known under various names, such as the Siège d'Antioche, the Histoire d'Antioche, and the Song of the First Crusade, and it follows the narrative follows the First Crusade from the Council of Clermont in November 1095 to the Battle of Ascalon in August 1099. And Pope Urban II's speech at Clermont in Auvergne included the call to arms that would result in the First Crusade and eventually the capture of Jerusalem and the establishment of the Kingdom of Jerusalem. And Godfrey Villon, one of the knights who features in the text, was, of course, the Duke of Loire-Lotharingia, and you can see the Duchy of Loire-Lorraine on the map. And he went on to become the first ruler of the Kingdom of Jerusalem. So how do we use crowdsourcing in the project? Well, an algorithm is used to tweet pictures of 2 lines at a time via Twitter from the second half of Bodleian Hatton 77. Users are directed to the website with 1 click and can type their transcription in the text box beneath the excerpt. Participants submit anonymous transcriptions, which are emailed to an expert moderator panel for checking and correcting. And the public transcription competition came about because ISARCA Luxembourg was tasked with organising an event for the inaugural ISARCA Community Day. ISARCA, formerly the Information Systems and Controls Association, is a global not-for-profit organisation that helps advance the positive potential of technology, and local chapters worldwide had to volunteer to do an activity. So as a board, we decided to base the transcription competition event around Crowdmap-the-Crusades, primarily because it was a citizen science project, and to combine that with a roundtable discussion on online safety and cybersecurity risks. There was, however, a challenge. We needed to transfer an activity which to date had taken place in a virtual environment into a live event. We had a very short timescale. We needed to create sufficient interest to attract enough volunteers, and creating an online leaderboard or other virtual reward system seemed quite a challenge in the time frame. And notwithstanding the fact that the audience for such an event wasn't necessarily one which really wanted to transcribe Old French on a Saturday afternoon. So as I was thinking about creating an online leaderboard, I was also considering GDPR. And on the next slide, I've just showed my thought process at the time, because, of course, in general, we can claim that research is in the public interest in EU countries. However, whereas you previously didn't always have to request consent, now you absolutely do. And the key point is that as researchers, we need to establish the difference between EU countries regarding how freely we can process data in the special category, and also the exemptions to the rights of data subjects set out in Articles 15, 16, 18, and 21 of the regulation, which governs the rights of access by the data subject. I'm going to come back to these points in greater detail in the second part of the presentation, but the other thing I wanted to mention was the process of anonymizing. Of course, as the process of anonymizing is equivalent to editing under the law, and thus makes you the content provider, it's always better to avoid this by anonymizing your data as you collect it. And also remember that if content infringes on copyright, then in theory you could be sued. So in terms of the approach taken to this project, I decided to keep the participants anonymous. And I did this by designing a competition on paper. We gave the participants numbers, so no personal data was collected. We did ask them to sign printed copies of waivers and an online waiver, which had been organised by ISACA headquarters. But I would point out that as it was part of a global volunteering day, the waiver chiefly required individuals to consent to having photographs taken, which could then later be uploaded to the social media feed. All participants received a free T-shirt with the ISACA Community Day logo, and I came up with some peer-reviewed solutions for the competition and invited colleagues from Sorbonne and Heidelberg to evaluate the competition during a roundtable discussion. Then after the event, we had a drinks reception and we awarded the winners' prizes. So my observations would be that actually all 20 participants, apart from one, took part in the competition, even though they were mostly interested in cybersecurity and new to Old French. All 20 participants stayed for the entire event, even though it was held on a Saturday afternoon. One of the participants made a video of the event, and there have been requests to hold the video again next year. And just while I run through the conclusions on motivation, I'm just going to show you the video that was made by one of our volunteers. So combining a game or competition with a reward for participation, the potential for winning a prize together with volunteering was very successful. Giving a free T-shirt to participants with the event logo could be compared to a form of group identification. Richter, Rabanne, and Raffaeli in 2015 argued that badges provide a kind of social shaping because they represent interactions that are shared among people who hold them. And we could draw a parallel with the purpose of a T-shirt branded with the event at which users have participated. And those of you who attended the keynote speech at the Gender for STEM conference here at the university 2 weeks ago would have heard Sophie Viget talking about how gamification techniques, such as online badges, are being used in her innovative pedagogical methods to teach C programming to participants in the globally successful École 42 scheme. Another way to motivate participants we've mentioned was to award points, and they're typically used to indicate an individual's progression and performance, and so they're likely to evoke self-efficacy and foster direct competition. This was certainly borne out by the reaction of some participants. Each was given a points-based score. Some were very competitive and, in fact, didn't want to hand in their competition for evaluation because they found it too difficult. Others were very keen to ask questions and learn about the scribe's hand. And one of our youngest participants convinced their father to buy them a medieval French dictionary after the event. So the group certainly seemed more cohesive at the end of the event than at the beginning. And if we consider the factors motivating volunteers, what's clear is that there's significant overlap between virtual and real-life environments. So what we found was borne out by what's already in research, which is raising the bar and increasing the challenge or end goal does lead to greater motivation. So the fact that we invited people to come and transcribe a medieval text without previous knowledge was certainly successful. A general conclusion would be that successful crowdsourcing projects require multiple interactions with users in order to maintain motivation. Right, I'm moving on quickly now to talk about GDPR in academic projects. And I want to begin by looking at the GDPR regulations relevant to research projects in Luxembourg. These have been mentioned before, but Articles 63 to 65 set out rules governing processing for the purposes of scientific or historical research or statistical purposes. And whilst there is a research exception in certain circumstances, it's important to understand what constitutes personal data and when you may need to check whether GDPR applies to your project. And on the next slide, I've got the appropriate measures in Article 65. Now, you can see there's a lot of detail. And what I've done in green is I've tried to highlight how many responsibilities are included in the legislation, which may require input or collaboration from the individual researcher. Above all, it's important to recognise that if you think that your project may involve the collection of personal data, the first thing you need to do is to check your data protection policy and liaise with your DPO coordinator in your department if you're at the university, or with the person responsible for data protection in your organisation. In the next slides, I've set out 4 key areas to consider at or before the planning stage in order to determine whether, in fact, you're dealing with personal data. So, in your ideal research project, if you're dealing with stories in social media, or personal stories in newspapers, or public court decisions, or interviews for a book, or IP addresses, or analytics on various browsing platforms, these are all alarm bells which should send you straight to the policy. Now, I'm going to begin by just looking at where the data's from and to see whether or not GDPR applies. And as you can see, within the EU, it may apply, depending on the data type. If it's outside the EU, again, it may apply depending on data type if the organisation or processor is processing European citizens' data. Also, if it's outside of the EU, and again, it depends on the data type, but if the organisation has an internet site which is accessible on EU territory in a language of the EU, again, you could come under the legislation. And the next slide, I've set out the key definitions for the different data types. And going on from that, I've also set out, which data types, to which data types GDPR applies. So you can see that if it's personal data or pseudo-anonymized data, then, it may apply, and we need to kind of go a little bit further. A-personal, of course, doesn't apply to persons, and anonymized we've mentioned previously, but again, really important to do this upon collection, not at a later stage. So when I was talking about the GDPR thought process used for Crowdmap-the-Crusades, one of the key points I made was that as researchers, we need to establish a difference between EU countries about how freely we can process data in the special category. So on the next slide, I've just set out the definition of data subjects and the factors to consider when we're processing personal data. And then I've also set out the special categories of data, all of which require a higher level of protection. And in terms of your own roles and responsibilities in your research, what I've tried to do is take the roles from the legislation and think about where the typical roles in a research project might fit. And rather than giving you definitions, what I've tried to do is include questions that you might work through if you're not really sure whether you could be a data controller or not. On the next slide, I've done the same for research assistant. I mean, this isn't complete. This is really just to try and help get into the mindset of thinking about GDPR as you're beginning to plan your project. So again, when discussing GDPR considerations for Crowdmap-the-Crusades, one of the things I did mention was about personal data and the requirement to anonymize or to have the appropriate legal base for processing. And so, again, this slide underlines the requirement for the data controller or the principal investigator to have a legal basis for processing personal data. And then, just going on from there, I've included the 2 methods of data processing which come under GDPR. So, of course, it's not only data processed by automated means, personal data by automated means, but it's also personal data processed in a non-automated manner. Now, up to this point, it's probably all seemed relatively straightforward. You may have been familiar with lots of the concepts, but once we get into the field of data analytics and GDPR, things begin to get more interesting and a little bit more complex. So who here uses data analytics for their research projects? No hands. I don't believe you. In their article, Data Analytics and the GDPR, Friends or Foes, Sophie Stallabaudian and Alison Knight highlight the perception that the objectives of innovation and privacy or data protection form an uneasy partnership. So examples are data scenarios where organizations are open to personal data they control to be reused, and to be reused for innovative purposes. So while data science provides opportunities to improve society, it also poses challenges. So we've got an ever-increasing volume and availability of data relating to persons being shared. We've got growing reliance on automated algorithmic processes to reanalyze them, and we've got a gradual reduction of human involvement and oversight. Data analytics aren't always applied to personal data, it has to be said. They can also be applied to anonymized and apersonal data. But by examining the apparent zones of tension between the practices of data analytics and some foundational pillars of data protection law, such as principles of purpose limitation, data minimization, and data protection by design and default, Stallabaudian and Knight make the case that the GDPR is able to usefully accompany data analytics practices and provides for some tools to restrict them when it's not possible to mitigate the high risks posed to individual rights and freedoms. So on the next slide, I've included the definition of analytics in Article 29 Working Party documentation. And what I wanted to just draw your attention to was definitions of first-party analytic systems and third-party analytics. So the first-party analytic systems, which are based on first-party cookies, are described by the Article 29 Working Party as posing limited privacy risks, providing reasonable safeguards are in place, including adequate information, the ability to opt out, and comprehensive anonymization mechanisms. However, it describes third-party analytics, which use a common third-party cookie to collect navigation information relating to users across distinct websites, as posing a substantially greater risk to privacy. So despite recognition of big data's potential for innovation, Article 29 Working Party flagged the significant risks to the protection of personal data and the right to privacy it can raise at an applied level. And it distinguishes between the production of statistics on the one hand and the other types of analytics requiring a degree of profiling for which more specific guidance would be needed. And so for the purposes of planning what data analytics practices you may wish to use for your project, it's important to understand this distinction and the accompanying GDPR implications. And I've included there the definition of profiling under GDPR. And also I wanted to draw your attention to paragraph 3.5, which I think is also important to be aware of, in that, in the context of profiling, consent has to be free, specific, and informed. The next slide, I just wanted to highlight the big data concerns associated with the usage of analytics on application. And certainly if I draw your attention to the last bullet, the consequences of automated decision-making also include inaccuracies, discrimination, and social exclusion, and ultimately creation or entrenchment of economic imbalance. So with this in mind, we can see how GDPR paragraph 3.5 is attempting to mitigate some of the concerns, certainly with regard to profiling. Another thing worth saying is that it is quite difficult to derive guidance for data analytics practices that aren't intended to produce statistics alone. Anonymization processes applied to personal data to protect individuals' privacy are more effectual when applied to organizations processing data relating to persons in order to detect trends and correlation in the information. However, risks associated with the potential for harm to flow to such individuals are not easily mitigated using technology. Even if re-identification of data subjects is never achieved, it doesn't mean that data protection risks have been appropriately mitigated, as data protection harm can arise even in the absence of re-identification. An example would be in the case of discriminatory treatments of individuals subject to automated decision-making. So it's important to decide what data may be made available for reuse, assess its quality, and decide what technological, organizational, and legal measures apply prior to sharing such data for reuse. I want to move on now to talk about compatibility of purposes, because previously, when we looked at the roles and responsibilities of the data controller, we mentioned informed consent as being the legal basis. However, that might not be possible unless a specific purpose can be formulated for transparency reasons. So organizations have got two other options. They they can rely on the doctrine of compatibility of purposes as per Article 6 of the GDPR if consent wasn't the original legal basis, or they can find a legal basis for secondary data usage analytics using legitimate interests of the data controller or third parties. However, in both cases, the principle of purpose limitation is still fully relevant and applicable. And even if the doctrine of compatibility of purposes applies, the principle of purpose limitation remains applicable, just like the principle of transparency per Articles 13 and 14. So my aim with this slide is really just to encourage anyone contemplating secondary data usage analytics to check your data protection policy and make sure that you've had appropriate advice. So I want to just draw a few more quick things out on data analytics, which is to say that I think we have mentioned the principle of purpose limitation of recital 33 previously, but if it's going to be relaxed, data subjects still need to be allowed to give their consent to certain areas of scientific research when in keeping with recognized ethical standards. And they should have the opportunity to give their consent only to certain areas of research or parts of research projects to the extent allowed by the intended purpose. So again, it's complicated. So if you feel like you're getting into this area, then before you do anything, make sure you've had some advice. Data analytics practices aren't always the same as scientific research. And indeed, if we compare kind of scientific research in the traditional sense, normally we would have to have research ethics approval before going ahead. And if we think about data analytics practices conducted for marketing purposes or marketing research, that certainly isn't the case. People who are described as data scientists may still be conceived as researchers, but what's important is that their research activities do not lead to measures or decisions regarding a particular individual. And then the last bullet, I just wanted to draw out this point about the justification for repurposing personal data. In this scenario, controllers would need to conduct a balancing test to assess whether their legitimate interests would be overridden by the interests or fundamental rights and freedoms of the data subjects. And it would need to include considerations of the risks and harms, adverse impacts on the individual. So it would really be a risk-based impact assessment, which would need to be followed by putting in the appropriate safeguards to mitigate risk to a safe level. And then finally, before we go on to machine learning, I just wanted to point out the fact that in the legislation, research is not described as a specific purpose. It is described as a specified purpose. And this distinction is quite important. And indeed, Article 29 Working Party made the point that the generic reference to research would not be sufficient. So the principle of purpose limitation should also be interpreted as requiring an identification of the scope and the consequences of the research activities, albeit negatively, which would then need to be meaningfully conveyed to data subjects for the purposes of transparency. And lastly, I just wanted to point out that you may have heard of this right to portability. Well, the right to portability of personal data under GDPR is only available when the data subject has consented initially to their personal data being processed, or if it was processed in performance of a contract. And then just finally, certainly data analytics practices should not necessarily be equated to research activities, and probably a better description would be experimental practices. So it points to why the GDPR uses a different term to describe data analytics, that of general analysis. Now I want to just quickly move on to machine learning. And there's a fantastic article by Laurent on how machine learning generates inequalities and how data protection instruments may help in mitigating them. And if you haven't seen that, it's on the bibliography. I really do recommend it. Nautz talks about how we might achieve fair machine learning by increasing multi-stakeholder involvement and dialogue. And he actually suggests using self-assessment measures such as the DPIA and codes of conduct, and says, we could perhaps look to further inform them with academic and societal debates concerning machine learning and fairness. And in turn, that could lead to unfair machine learning outcomes being better identified and mitigated. I've also got, I did put algorithmic inequalities on the slide because I just wanted to make the point about machine learning processes differentiating. So whether they categorize, classify, prioritize, or filter data, the patterns and correlations machine learning processes find can form the basis to differentiate between individuals and also groups of individuals. So due to the increased usage of machine learning processes, the risk is that these differentiation processes might result in unfair results increasing too. Now, as I'm over time, I think what I might do is invite you to come and talk to me about the Internet of Things at the end. And I just want to draw your attention to a project plan that I drew up with researchers in mind. And what I've tried to do is map that to the data protection policy in the university, just so that you've got something to work from when you're conceiving your project. So again, please do have a look at that. And then my conclusion was just some areas where there's some really interesting research happening and critical thinking about the development of this legislation. And finally, useful resources in Luxembourg. The APDL is a great resource, as is the CNPD. There are some great websites if you just want to refresh your mind of the key definitions. And yes, you've got bibliography at the end. I'm sorry for going over time. Thank you.
No problem.
So, good afternoon, everybody. I was going to start by appealing to your sympathies by saying this is my last 3 days as an EU citizen, but unfortunately you just had Emma and she didn't even call for your sympathies. So, but in any case, what I can say is I think we're 25% of the speakers, so you're really going to miss us after the 31st. I'm the director of the Data Directorate at the European Commission's DG Connect, which is Communication Networks, Content and Technology. We are not the DG that deals with the GDPR because that's part of the Justice DG. I'm in charge of the Commission's policy and research and innovation activities in support of data. I would like to thank the Restina Foundation and the University of Luxembourg for inviting me to discuss a topic that's very important to me, but also to the institution I represent. The use of personal data in Europe in a secure way, guaranteeing the respect of the rights of the individuals. We all know that over the last decades, data has become an important factor that revolutionizes every aspect of our lives. Our goal is to create a single market for data in Europe, an information space where data will be used by Europeans and for Europeans. The Commission recognizes the importance of data as an enabler of many technological innovations in order to improve the way that we live, the way we provide healthcare, and to produce goods and services. The challenge that we face here in the EU and in other places too, of course, is how to empower the citizens so that they have a stronger say on which data about him or her can be used and for which purpose. I'm going to go into more detail on this topic. However, before that, I would like to move one level up and say a few words about the work of my directorate and the wider policy framework of the Commission to realize the digital single market. I'm happy to say that my directorate is the only one of DG Connect which is entirely based in Luxembourg. We're at Cloche d'Or. We are nearly 200 people in DG Connect in Luxembourg. And the mission we try to accomplish is threefold. We try to set up framework conditions for a thriving European data economy. We try to exploit the potential of the European cultural heritage and creative industries and foster the modernization of education and training systems. And we try to contribute to removing digital barriers that lead to social and economic disparities such as language and accessibility, because we feel very strongly that the digital single market should be available to all EU citizens, not just to the ones who are able-bodied and speak English. And last but not least, we try to promote a better internet for children by protecting and empowering children online. So we're responsible here in Luxembourg for the Safer Internet for Kids campaign. On this last point, I'm very proud of our close cooperation with Be Secure, who you heard earlier, who are our Luxembourgish partner in the Safer Internet Network, and which is co-funded by the European Union. Transparency on the use of personal data is paramount for all users of all ages, and the European Commission, through the Better Internet for Children strategy, is committed to promote a safe and responsible use of digital technologies. In 2 weeks' time, it's the Safer Internet Day, which is celebrated now in 140 countries throughout the world. All these are crucial elements in order to realize the broader strategy known as the digital single market. But what do we mean by that? What we mean is that building the digital single market means bringing the benefits of the digital revolution to every single European citizen. And to achieve that, we need to nurture a flourishing data economy. It's been estimated that the value of the European data economy for the 28 member states is expected to grow from 377 billion euros last year to over 1,000 billion by 2025. If the right framework conditions are put in place at European level. Our vision is exactly that we put in place all the right framework conditions so that data is accessible and reusable across borders. So we hear a lot about what's happening in China, what's happening in the USA. What we need is for the EU also to be one single market and not 27 markets. For and by different types of organizations, and also for and by different economic sectors. In April last year, we put forward a data package which included 3 different types of measures, each adapted to the type of data it covers. First, the new directive on open data and reuse of public sector information that has made more public data available and easier to use in order to boost growth in innovation. Secondly, there is an updated recommendation on access to and preservation of scientific information, which has improved the availability of data generated in the context of publicly funded research. And third, our guidance document on sharing private sector data, which also contains a number of key data sharing principles, which is expected to help break down data silos and create fair markets where smaller actors, SMEs in particular, can innovate. In this document, we have also outlined governing principles for business-to-government data sharing in order to help the public sector to embrace the opportunities for using business data, but for public good. On this matter, the Commission will release in February a report which has been produced by an expert group on business-to-government data sharing, which was set up in 2018 and has just written its report. We are aware that creating the right conditions for data innovation is not enough. It is absolutely crucial that we supplement these initiatives with adequate investment into related technologies. The Commission already supports industry by giving financial assistance for the developments of data-driven innovation, business incubators, industrial data platforms, and innovation hubs under the Horizon 2020 programme. Beyond 2020, Horizon Europe will be the EU's flagship programme to support research and innovation. For Horizon Europe, the Commission proposes to invest 15 billion euros in the digital industry and space cluster, with artificial intelligence as a key activity to be supported. Moreover, we have a brand new Digital Europe programme, which has been agreed by the other institutions, but we just don't have the fixed amount of money yet. We're planning to invest almost 2.5 billion euros in deploying data platforms and artificial intelligence applications. It will open a critical mass of quality data across sectors and borders. Let me now move to the core of today's discussion and outline some elements around the use of personal data, including the development of privacy-preserving technologies. The personal data economy is mainly driven by organizations who control data flows. The individual often has the role of a bystander. While he or she has a right to withdraw consent for the processing of his or her data, in the absence of easy-to-use tools or processes, this right often remains ineffective. And I don't even have to add that if you have children or teenagers, mostly the rules are incomprehensible to them. With the General Data Protection Regulation, the Commission has laid a solid basis for a human-centric data economy by ensuring that individuals remain in control of their data. And we're proud to say that the EU legislation on protection of personal data is the most advanced in the world, and we do a lot of traveling for our job, and the EU has become a model for many countries worldwide on this particular subject matter. To ensure an efficient implementation of the GDPR, DG Just, which, as I said, is the one who did the GDPR, is carrying out at the moment an evaluation of the legislative instrument. It's expected to deliver a report before the summer. If you are willing to contribute to the evaluation, we are willing to channel your input to the unit responsible, because obviously the more responses we have, the better the evaluation, or the more in-depth the evaluation will be. In addition to GDPR, technology is now available to put the individual at the center of the data economy and turn them into active agents. Personal data management systems and novel techniques of distributed machine learning could allow to control existing data flows with greater ease and effectiveness, to trigger novel data flows, and to contribute to the development of services building on big data and AI in a privacy-preserving manner. The deployment of these technologies is not realized yet. The Commission is currently reflecting on how to support it, because it will facilitate the exercise of the portability right by individuals and will contribute to the effective application of the GDPR. It's extremely important to succeed on this front, and not just because personal data is crucial to the development of the data economy. It's only when citizens feel that they are in control of their data and are confident their data is processed in a secure way that the huge potential of personal data can be unleashed. I want to give you an example of how we are trying to change the negative perception some people still have about the use of their personal data by supporting projects based on the introduction of privacy-preserving technologies. If we consider the biomedical sector, issues of data subjects' privacy and data security represent a crucial challenge, more perhaps than in any other industry. This is why the Commission is partly financing the My Health, My Data project. It will help provide better healthcare to citizens by allowing hospitals to share clinical data for research in a secure and auditable way that will guarantee all privacy measures are respected. The realization of My Health, My Data fosters a broad vision in which patients and citizens will have new ways to gain access and control of their personal data. Hospitals will share and valorize data collected in clinical care to improve health services, support research, and accelerate innovation under full legal and ethical compliance. And industries will be able to access integrated and heterogeneous data sets to boost drug and technology development in a strict privacy protection regime, also reducing overall cost time and time for data transactions. I encourage you to look at the project's website for more detailed information on the technology side. Another project that we're helping to fund is called SPECIAL, Scalable, Policy-Aware, Linked Data Architecture for Privacy, Transparency and Compliance. I don't think they did very well on getting a snappy title apart from the special. It allows citizens and organizations to share more data while guaranteeing compliance with data protection, thus enabling both trust and the creation of valuable new insights from shared data. So it supports the acquisition of user consent at collection time according to legislative and user-specified policies. It caters for privacy-aware, secure workflows, including usage, access control, transparency, and compliance verification. And it provides a dashboard with feedback and control features that make privacy and big data comprehensible and manageable for data subjects, controllers, and processors. I'd like to talk about all the projects we are supporting in the field of privacy technologies, but my time is running out. I hope I have given you a sense of the work we are doing at the Commission to harness the potential of personal data to benefit European society and economy, but always putting the human being and its rights at the centre. And we will keep doing that. So I am sure most of you have heard from the media that the Commission is going to release, together with a strategy on artificial intelligence, a new data strategy in February. We have a new European Commissioner, Thierry Breton, who has been giving a number of press interviews about his enthusiasm for data. In fact, he said his 3 priorities in his new job were data, data, and data. You should look out for this, because it's coming very soon, and it will be followed by an online public consultation. It will be launched just afterwards, and you'll be able to give your opinion. I can anticipate to you that it will contain a mix of policy and funding measures to support the creation of a genuine single market for data. I think our Commissioner feels very strongly that even if we have a certain amount of data today, it's very small the amount of data there will be in 5 years' time. And whereas most of it now comes from fixed sources, in 5 years' time it will mostly come from Internet of Things and different sensors out in society. And so the whole situation of data is going to be changing, and that we need to react now in order to make sure that we can be very successful in the EU in managing and making the most of the data economy. Individuals and companies will have more control on the use of the data they generate, and businesses need to have easy access to large amounts of high-quality data, as indeed they do in other continents. Thank you very much for your attention. Can I just say, if you have any particular questions, especially I know there are a lot of researchers here, so my email address is Gail, like it's here, gail.kent@ec.europa.eu. I think it's anyway on the site, and we're very happy to answer more technical questions afterwards. Thank you very much.
Thank you, Gail. Yeah, I also would like to thank you on behalf of the Resieno Foundation and the University for Luxembourg for staying with us this morning. I hope you enjoyed the talks we could provide to you. As you know, this was the 3rd edition of the Data Privacy Day. We will do a next one next year, obviously. In the meantime, there will also be on the 6th of October an event which is just called Cyber Day LU, in part of the European Cybersecurity Month. Last but not least, thank you for your participation, and I also would like to give a big thank you for all the people supporting this on a technical level, the social media support, video recording, people doing the registration process, advertising, and so on. On your way out, we are providing you a small gift as a takeaway, so feel free to take it. Thank you very much.